Concept of law. The rule of law is a basic and dynamic legal concept that stresses on the supremacy of law over all and sundry. The rule of law is a liberty-centered constitutional concept which stipulates that everything must be done in accordance with the law. The rule of law presupposes a governing system whereby everybody is subject to the ordinary law of the land. This implies that everybody, both authorities and ordinary individuals, are subject to law. Rule of law should dominate things done in accordance with the laid-down procedure provided by law. Rule of law emanated as a result of quest and urge in American philosophers to curtail the despotic and tyrannical nature of rulers. Historically, rulers usually make draconic laws which are against the interest of the people, and this violates the rights and liberty of the people. That is why, according to John Locke, tyranny starts where the rule of law ends, and it is a truism that a state of anarchy exists in the absence of rule of law. Thus, rule of law came into existence in order to safeguard the liberty and rights of the individuals in the society. It is a principle used to ensure that rulers do not become absolute, tyrannical, and despotic rulers. For instance, there is almost absence of rule in the military rule. Military rule is marked with autocracy and rule by force. People are denied civil liberty. The rule of law is a fundamental principle accepted as a standard not only for judging the performance of the government, but also for determining what is beneficial. The rule of law is the pillar of constitutional democracy. According to A.V. Dicey, the chief proponent of rule of law, in his introduction to the study of law of the Constitution, he states that rule of law has to do with three things. In other words, there are three cardinal elements that must be observed in a society where rule of law is in prevalence, such as supremacy of law, equality before the law, safeguard of fundamental human rights, and respect to the order of the court. 1. Supremacy of law. According to A.V. Dicey, the rule of law entails first, the supremacy of law. In other words, before we can say that rule of law is in prevalence in a society, there must be supremacy of law, which simply means that law is supreme. Supremacy of law means that everything must be done in accordance with the law. This implies that both the government and the governed must always justify their actions in law. That is to say, government activities must be conducted within the framework of an organized rules and principles, which restricts discretionary powers. It is expected that the government business should be carried out in a way to avoid arbitrariness and dictatorial tendencies, because if the discretionary power is allowed, those in government will use it to the detriment of the less privileged members of the society. In accordance with the spirit of rule of law, in relation to the supremacy of law, government is expected to act in accordance with the provisions of the law. Fundamentally, in accordance with the proposition of A.V. Dicey on the supremacy of power, there is a presumption that man can only be punished for a breach of the ordinary or extant law of the land. Someone who is accused of an offense should be treated and regarded as innocent until he is found guilty by the law court. The second presumption is that a breach of the extant law of the land must be adjudicated by the court, and the person should be punished if convicted of the offense. Therefore, in a society where the rule of law is in prevalence, the government is denied of discretionary, arbitrary whims and caprices, because activities of the government must be carried out within the framework of a defined rules or provisions of the Constitution, not in accordance with the dictate of their mind. 2. Equality before the law. Furthermore, according to A.V. Dicey, rule of law connotes equality of all citizens before the law. This simply means that both the governor and governed are equal before the law. It entails that no person should be given more advantage than others before the law court. Dicey posits that rule of law entails equality before the law, or equal subjection of all classes of people to the ordinary law of the land administered by the ordinary court. That is to say, all persons within the society should be subject equally to the ordinary law of the land. This simply means that nobody is above the law. It was on this view that Justice Taylor, in Olayori's case in 1969, said, "If we are to have our actions guided and restrained in certain ways for the benefit of the society in general and individual in particular, whatever status, whatever post we hold, we must succumb to the rule of law." For instance, in Nigerian society, Every individual and even the president should be equal in respect to the rule of law. No one should be above the law of the land. In other words, every citizen, irrespective of sex, occupation, status, age, and rank, should be equal before the law, and no one shall have preferential treatment in any matter before the court. Third, safeguard of fundamental human rights. In addition, A.V. Dicey equally posits that rule of law means safeguard of fundamental rights of the citizens. Before rule of law can be said to be in prevalence in society, there must be safeguard of human rights. Human rights, according to A.V. Dicey, is what made us human different from animals. These are natural rights endowed on human beings by God by virtue of the fact that we are human, and these rights are inalienable. There must be respect to human rights, which could economic, political, and social rights. Government and its agencies must respect the fundamental rights of the citizens, for there to be prevalence of rule of law in the society. According to Dicey, the fundamental human rights are not a creation of the Constitution. Human rights existed before the Constitution. A.V. Dicey was of the view that fundamental human rights of the citizens should not be incorporated in the Constitution, because during the military regime, if the Constitution is abrogated, the fundamental human rights will also be thrown away. But he suggested that fundamental human rights should be found in the judicial opinion buried in the law report. 4. Respect to the order of the court. Additionally, some jurists and scholars have included the rule of law to be respect to the order and decision of the court. In a society where rule of law is in prevalence, it is expected that both government and the citizens have respect to the order, decision, and processes of the court. In the case of Lagos State against Ojukwu, the Supreme Court dealt passionately and extensively on the need to obey the court orders and states that it is a very serious matter for anyone to flout a positive order of a court and proceed to insult the court further by seeking remedy in higher court while still on contempt.